Good morning, greetings. My name is Barrett Brown. I'm the Chief Administrative Officer of the Oklahoma Medical Marijuana Authority. Seated to my right, your left, is Ashley Krall. She is the Director of Government Affairs. And seated to my left, your right, is Portia Riley. She is the Communications Director for the Medical Marijuana Authority. So today's meeting is the public comment hearing. We are here to receive comment from you guys, the public, on proposed permanent rules to Oklahoma Administrative Code, Chapter 442, Title 442, Chapter 1, and Title 442, Chapter 10. These rules are implementing legislation that was passed by these guys during the 2025 session. And this meeting was posted in the Notice of Rulemaking Intent and published in the Oklahoma Register and on the OMMA website. It is currently 9:08, so everybody should have had plenty of time to sign in. Anybody who wanted to speak must have signed in by 9:05. Anybody who wants to speak that didn't get an opportunity to sign in at 9:05, you can make your request and we'll see how we're feeling and how much time we've got. If you'll please do us a favor and sit at one of these two seats right here, and then turn your microphone on, which you'll notice is indicated by the red light, so that way people who are watching online can hear you, and I can hear you, because I don't hear too good. And if you would please state your name, the organization that you represent, if you are representing an organization. If you're representing yourself, so you can just indicate that. Each speaker will have 3 minutes. We've got quite a few folks in the building, so please try to keep your comments focused, concise, not rambling, because you only have 3 minutes. And everyone who gives a comment, you will receive a response in writing from the authority on your comment. Every single person who makes a comment today. One last thing, I will mispronounce somebody's name. I'm trying to read names in other people's handwritings, so just give me a break. I'll do my best, but apologies if I butcher your name. And first, just going in order of the sign-in sheets as they were signed in, Mr. Kumbis, John Kumbis.
There we go. All right, what's up, everybody? My name is John. I'm with JKJ Processing. Man, I was going to talk about some of the rule changes, but I'm going to change it up a little bit. I'm tired. All these people are tired. All the hoops we have to jump through, all the calls to customer service at OMMA, and everything. And I just wish that the OMMA would see the struggles that we go through every single day, the hoops that we have to jump through to be legal, to do things the right way for the people that rely on us to pay their bills, to feed their families and stuff. And I really think that's where OMMA is missing it. And I know this is a talk about the rules, and there's so many more people in here that are smarter than me that are gonna talk. And I just want to be the first one to just say that, I appreciate you guys having this meeting. I know you guys' work is hard work as well, but I just wish that you guys would see the struggles. And I wish that, I wish OMMA and everybody else would realize that we're all human. We all make mistakes within our organizations, within our businesses. And a lot of my friends are getting shut down because of just simple clerical errors or human errors. Nothing, if you've got 50 pounds of flour sitting by your back door with no metric tag, no identifier on it, okay, you're probably doing something a little shady and we need to, get rid of you. But it's disheartening for me. And, I've been kind of quiet for the past 3.5 years. I used to be a loudmouth, and when I walked into this room, the people sitting up there would be like, fudge, John's here. What's going to come out of his mouth? But I've kind of taken a step back, thanks to my good friend Brandy Frisbee here, on reeling me back in and stuff. But, I know you guys' work is hard, and you guys get a lot of hate emails and stuff from people that just don't understand how this business works. So I will say I do appreciate you guys having this meeting and listening to everybody and saying that everybody's going to get a response from OMMA. But I just want you guys to know that we're tired. I've been doing this for almost 7 years, and honestly, I do it now because of the people that rely on me every single day inside of my OMMA organization. But other than that, man, like I said, there's way smarter people in this room that are going to talk about a lot of other stuff, and that's really all I have to say.
Thank you for your comment, Mr. Kumbis. Up next, we have Cole Allman.
Good morning. This morning I'd like to talk about 442-10-8-1-6. Where's that? I, and I. All right. So, analyte testing requirements for distillate. When you have distillate test over a certain threshold, you have to run confirmation tests. And when the rule went into effect, it was very important that we do that. However, after that rule went into effect, we changed what products we were testing and what was final form. When we made the transition for final form, the intermediary product of distillate overwhelmingly stopped being tested industry-wide. But when those samples do come in, we're required to test them not once, not twice, but 3 times. And it's a unnecessary burden on the industry. It delays test results for these clients that are the intermediaries between the grows and then the processors that are making their final goods. And we'd really like it if we could get that condensed down and removed since it's no longer serving the purpose for which it was written. And that's all I have today. Thank you.
Thank you, Mr. Allman, for your comment. Up next, we have Henry Sprague. I really hope I didn't mess that up. Sorry, I forgot to mention this, but the cameras are also connected to the microphone system. So when you activate that mic, one of these cameras will automatically find you, so that way the people that are streaming online can see you as well as hear you.
Oh, okay, can they see me now, I guess?
They can see you now if that's what you wish.
I'm 80 years old, so I'll talk real fast. So I'm Google authorized representing contractornews.com. And so OMMA says this is another business of mine. OMMA says we have an active license, but are in renewal pending. So we're denied access to transportation agent application. This is causing me another headache. I'm tired too. I want to just say this. I'm really tired. I'm sorry. I just want to just get it out. I feel better now. So that's about it. I don't want to be negative, but you have 200 employees. If I had 200 employees, I could build a freight train. 200 employees, why can't you take care of us promptly and fast? That's it. Thanks.
Thank you, Mr. Sprague, for your comment. Okay, the next name is scratched out, so I'm just going to call what looks to be John. Oh, wait.
Yeah, I signed the wrong one. Sorry.
As I started saying, I recognized it. All right, up next, we've got Mary Lane Porter.
Hey everyone, thank you first of all for coming, and thank you guys for being professional today and respectful. That's definitely our goal here, is to get things done as much as possible. So I wanted to comment on OAC 442 10-5-1 113D, amended to make employee credentials valid for 1 year. I think that's great. The biggest concern, I'm sure a lot of you guys have heard, that we were not able to renew this week due to the authentication error online, which we know there's been a lot of portal issues. We've been experiencing issues for about 9 weeks now, so my biggest concern is that when these dates come around, and I'm thankful that we get a full year after versus just the January 31st date, my biggest concern is that when we are doing everything right, communicating with calling, emailing, contact forms, and we're still not able to get that timeline correctly just because it's taking so long, there's so many calls, that somehow we can put in the system that we can get an email or written extension from you guys if we follow the right steps and prove that we follow the right steps, so that we can continue to operate if it's going beyond that timeline, because we have been experiencing issues since October 28th that's made it difficult on some of these things. And since the credentialing started having issues this week already, we're just trying to get ahead of the game to make sure we can continue to operate after January 31st.
Thank you, Ms. Porter, for your comment. Up next, we have Kelsey Palmer.
Good morning, y'all. Thank you for having us here today. I will keep my 5 points brief. Ashley, I know they're in your inbox as well. But first, I would like to start off on the topic of process validation. And I apologize, I'm with Apothecary Extracts and Apothecary Farms. We would like to see the rules that have been put in place for process validation become more operable, right? We see the legislative intent that was intended, but the rules kind of contradict themselves in that fact, right? They are not operable currently, and we would love to see that change to make it more efficient for businesses to use what is currently put in place legislatively. Secondly here, we would love to see a reassessment of how transporter agent licenses have been assigned. Would love to see that assigned to an individual and not to a business. Speaking from someone who, really generally runs our business in Oklahoma, and we're vertically integrated. I have 5 dispensaries, a processor and a grow. It's a lot of specific licenses to apply for myself or anybody driving, and would love to see that narrowed down into one for each individual and just associated with that individual. Third here, would love to see some clarification on the rules regarding displays. As a lot of dispensaries, I'm sure, do not let their patients handle displays, but we would love for our patients to be able to view the product, right? They don't need to smell it, but we would love for them to see what that product looks like. We would love to see some clarification in specifically 10-5-14, applying that if it is not handled by the patient, that it does not need to be wasted if it is just being displayed and it has been protected from being contaminated by that touching of the patient. Next, we would love to see some movement on the storage and retention of metric manifests, right? We are blessed to be able to use metric and have everything all in one place, but it's still a lot of paperwork that we physically have to keep on hand at our facilities for 7 years, right? A lot of states have moved over to the digital retainment of these manifests as you are signing them digitally when you accept something in metric. We would love to see that paper be removed, number one, to save the environment, but also save our filing records. Obviously, we still recommend that somebody transporting marijuana has a physical manifest with them, but avoiding that retainment of 2 copies at each licensee. Lastly, would love to see some clarification on the rejected transfer, specifically, let's see here, in 10-3-6, 10-7-1, removing the fact that a product, if it is rejected, does not need to be wasted. We see a lot of labeling errors, and that would be the majority of products that we reject, is something that has the wrong label. Also giving maybe the licensee a slight window. I know Mr. Gallagher, who is with our company as well and unable to be here today, has recommended a 90-day window to return the rejected product to the originating licensee without destroying that product if it has been untouched, specifically for the labeling issues. And that is all I have today. Thank you, guys. I appreciate you.
Thank you, Ms. Palmer, for your comment. Up next, we have Lee Bayless.
Good morning. Gives me great pride to drive up Lincoln Boulevard and see the state capitol, knowing that as an individual you can come in and have your voice heard, and it's nice to know that there's people sitting on the other side of the counter that take that same respect that you hear our voices too, so thank you for that. A little bit of background, I'm your smallest grower in the state. I grow 60 to 80 plants. I've had my license since 2018. Passed every inspection, never had any fines, never had any problems anywhere. A couple things that I want to talk about. First of all is safety. Your signage requirement of putting a sign in front of your building. I understand. I'm on a residential property, 5 acres in the country. So advertising to everybody driving up and down the street, it's not the most beneficial for my safety. I would maybe suggest that you put a waiver requirement, an option. If you've been in business 3 years or 5 years, you know where we are by now. So we should be able to maybe not have to put the sign up or make it optional once we've been in business long enough. Secondly, every time I call the OMMA, they're always nice and respectful, but they've been trained to say, we can't give you any legal advice, consult a lawyer, which automatically creates an adversarial relationship between us. So every other state agency, you can call the Oklahoma Assessor's Office, you can call the tax collector, you can call the Realtor's Office, Secretary of State. Everybody has a way to give you some advice, whether it's an executive committee, whether it's somebody that you have internally that you can really escalate certain cases up and get some answers to without having to have us pay for legal fees or have you pay your lawyers and have it wait weeks and weeks and weeks to get answers. Sometimes just sitting across the table talking to people with common sense, you can come up with a solution that's workable for everybody without all the time and energy that's getting wasted and expense. So I would suggest that you may consider putting in some kind of a executive resolution committee as some step in the process of the calls that you get. Thirdly, last year when I came here, I spent my whole time talking to you about my difficulty of renewal because my wife and I both had our names on our property and they were requiring me to add her as a license holder or put up a surety bond, which was completely not listed anywhere in the rules. My local congressman, Robert Manger, got with Mr. Fettgatter and they worked with Ashley quite closely and they were able to solve that in May. However, I still had to pay the $2,000 surety bond to get my license not in jeopardy, and it wasn't renewed until May. So I paid the $2,000, not wanting to jeopardize my license. And even the email that I got back later says, you know, hey, thank you for bringing this to our attention. We had to retrain our licensing team to ensure consistency. Thanks for bringing this to our attention. So when I was growing up, if your dog got on your neighbor's property and ate your chickens, they'd come over and say, hey, sorry, we pay you back for some of your chickens. You know, your dogs ate my chickens this last year, made me pay $2,000 that I shouldn't have had to pay. So what I would suggest is that maybe instead of just writing me a check or refunding, that maybe you credit me towards my next relicensing fee or some way to see if there's a way to make that $2,000 a little more palatable that I shouldn't have had to pay. I brought copies of that email and also my bond for you to have for your records.
Thank you for your comment, Mr. Bayless. Next, we've got Mr. Matthew Phillips.
Good morning. Thank you for taking the time to hear the feedback on proposed permanent rules. My name is Matthew Phillips. I'm the CEO of OKCTL, a licensed testing laboratory in Oklahoma. I would like to start by expressing my gratitude for the limited rulemaking as it pertains to laboratories this go around. As many have said, we're tired and we greatly appreciate that break. I have a few minor comments to make. First off, on manufacturer instructions. Regarding the proposed rules requiring laboratories to follow manufacturer's instructions, while we're disappointed that you have to say that, we greatly appreciate you addressing it and solving that problem for us. My next comment is relating to microbial enrichment in the proposed rules. While I understand the desire to clarify that enrichment is not required for quantitative assays, The language creates a new point of ambiguity. The term non-quantitative is not defined anywhere in OMMA rules, which leaves rooms for interpretation. A laboratory could argue that any method producing a numerical result, including qPCR methods that report CT values or estimated CFU counts, constitute a quantitative assay, thereby avoiding enrichment requirement entirely. I have a few proposals. Of course, decision's ultimately yours. One, you could be more specific, explicitly stating that total yeast and mold does not require enrichment. Or alternatively, define quantitative and non-quantitative, accomplishing the same thing. Alternatively, as an overarching improvement, you could limit total yeast and mold testing to auger-based methods, which would improve the consistency and reliability across the entire industry. And then finally, you could consider removing total yeast and mold testing altogether, as many of our peer states have done recently, or increasing the FEL limit to closer to 100,000 TFU per gram, as many of our peer states have done. Next, as Mr. Allman mentioned, distillate potency confirmation has been a pain point since final form testing was introduced. There's an undue burden on testing laboratories and licensees alike. Those clients that are doing testing on distillate are largely going above and beyond to ensure product safety for patients, and they're being burdened by additional potency verifications. While at the time it was totally appropriate and appreciated, now it is an undue burden. We would love to see that backed off to just the standard potency test. Finally, as I'm sure many may state later on in the meeting, I have significant concerns regarding the changes regarding the administrative law judge and administrative hearing processes. Changing from an administrative law judge to a hearing examiner raises concerns about due process for licenses. Hearing examiners historically lack the statutory independence afforded to administrative law judges. We would greatly appreciate OMMA providing an explanation as to why this change is being made, clarification on the impact, if any, that this will have on the independence and qualifications of the individuals adjudicating cases. Thank you guys very much for your time to be here today.
Thank you, Mr. Phillips, for your comment. Up next, we've got Mr. Brandon Mosley.
Good morning. I am Brandon Mosley with Baseline Laboratories. I'm going to talk. I'm going to limit my talk to yeast and mold, essentially. First and foremost, so all of us here in this industry should be first and foremost concerned about patient safety. Period. It's no secret that it's difficult in the state of Oklahoma for growers to pass yeast and mold testing if it is done correctly. It's so difficult that it's common knowledge that you can potentially take product to certain laboratories and get a different result than you can at other laboratories. At one point, there was a testing laboratory that erroneously tested a large number of samples for yeast and mold that provoked a recall from the authority. My understanding that these erroneous results were all analyzed by genetic assay, or qPCR as it's more commonly termed. As a whole, cannabis testing laboratories in the state of Oklahoma are really considered kind of a joke because we can't all get the same number. And I think a lot of that is, I know the standardization rules that you guys put out were designed to eliminate a lot of that, but we need to go a few steps further. There's simply, with the genetic assay, there's simply too much what I call hocus pocus going on, and what I mean by that is with these different qPCR platforms, there are for yeast and mold specifically, there are just random things that have to be done to arrive at a quantitative number for yeast and mold by genetic assay. And what I mean by that is there's stuff that you're having to introduce by one manufacturer's protocol that eliminates DNA that is supposedly dead. I don't know if it does or not. I've never been able to prove that it did or not. There's another platform that you actually send your results into them and they send you a number back. I mean, this is all done with mathematical formulas that were never meant to be applied to analyzing a large number of species by genetic assay. When you talk about yeast and mold, you're talking about, in the world, you're talking about an estimated number of over 2 million species. It's a vast number, and if you'll draw from like when we all took elementary science, it goes kingdom, phylum, class, order, family, genus, species. So, I mean, that genetic assay is designed to identify a specific species, not a vast array of 2 million different species of compounds, because it's all done by genetic sequencing. So, like I was saying, genetic assay attempts to quantify yeast and mold by genetic sequence, and golly, I got so much more that you guys need to hear.
You can finish.
Are you serious?
Yeah, you can briefly wrap it up, yes.
Okay, so real quick, I mean, we're talking about colony forming units is what you guys' rules say that we need to report these results in. Let's get back to counting colonies on an auger plate or some type of a Petri film, a Hardy plate. Let's get back to where we're actually counting colonies of yeast and mold and not doing some kind of hocus pocus for genetic assay of this vast number of species that obviously don't have the same genetic sequence, is what I'm trying to get at. Appreciate you guys' time.
Thank you, Mr. Mosley, for your comment. Up next, we've got Austin Woods.
Hi, I'm Austin Woods with Wild West Compliance. I'm going to try and keep this short as I can because I think my dad's fixing to use that 3-minute mark as more of a target than a restriction. I just want to say thank you for upping the sample jar limits to 3.5 grams. The look on the faces we'd get when we tell a dispensary owner that they had to use a tag to waste a 0.5 gram was not fun sometimes. And then the next is 10-5-6, I6, states, except as it is otherwise provided in Oklahoma law or these rules, violations which have been deemed as correctable by the authority and identified as such in a written notice of violation shall be corrected within 30 days of receipt of a said written notice. Are we going to get a list of violations that are deemed correctable? If so, where can we see it? And then 10-3-1F, medical marijuana transporter warehouses that are licensed and approved by the authority may temporarily store medical marijuana concentrate, and medical marijuana products, provided that all temporary storage is documented, tracked, and traceable in the state mandated seed-to-sale tracking system. Can we also get a hard definition of what is considered temporary? Because if not, then it's not really going to change anything. 10 years out of 100 years seems temporary versus 1 day out of a week can be deemed temporary. Thank you.
Thank you, Mr. Woods, for your comment. And now, Mr. Woods, the elder.
So I'm Jeremy Woods, Wild West Compliance. I'm here today to discuss the proposed Rule 442-10-5-8D7. Change the wording up a little bit. Women should not use marijuana or marijuana products during pregnancy because of the risk of birth defects. Once you remove the word medical, that was after or and before marijuana. Are you going to give dispensaries 90 to 120 days to sell their existing inventory? That was wording that matches what is in current state regulations on page 68. Out of the 5 dispensaries we looked at in the last week, we have a minimum of $50,000 worth of inventory that would have to be wasted. Because the wording actually matches what's in our regulations and not what's on state statute. A dispenser cannot add the correct labeling to the package because Title 63 on page 74 or 748, manufacturer includes any person who packages, repackages, or labels any container of any controlled dangerous substance. So therefore, they can't actually come in and add the actual wording to change what we want. The wording does match what's in Senate Bill 518 that was passed May 21st, 2025, to go into effect November 1st of 2025. However, on July 12th of 2025, the regulations was updated to the existing language, and all you guys added was the driving label. You did not actually change the wording on the other side. So can we get a little time for dispensaries to actually sell what's actually in packages? I mean, we was in a dispensary yesterday that received about $12,000 worth of product, and every one of them had the correct labeling that matches our regulations currently. If OMMA chooses not to allow the 90 days for dispensaries to sell what is in current inventory on the correct wording or the current regulations, because the Senate Bill 518 does state it goes into effect on November 1st, then I ask you to look at Senate Bill 518, page 2, number 5, states that labels on the container shall not make any claims regarding health or physical benefits to the patient. We all know that we have labels out there that have health benefits. They've been doing it for a long time. Some dispensaries get wrote up for it, some dispensaries do not. Can we get it across the board? Either allow it or you don't allow it. FDA says we're not allowed, regulation says we're not allowed, but people still do it. That's it. Thank you.
Thank you, Mr. Woods, for your comment. Next, we have Mr. Jeffrey Havard.
Thank you. All right, so yeah, my name is Jeff Havard. I am the owner and lab manager of Havard Industries, a transparent and live streaming testing lab located here in Oklahoma City. We really are trying to encourage other people to be transparent and also live stream as well to help kind of instill trust in the industry, which we think is like much needed at this point. So we have submitted the majority of our comments online already. However, we wanted to emphasize a few particular points that we thought were especially important. Number one, we would like to see basically the majority of the changes to the administrative law rules and process in court completely removed. And in particular, we have a huge objection against having the administrative law judge removed from the administrative court process and instead replaced with the hearing examiner. So we feel like this is probably going to be like an OMMA personnel whose either pay or job security may be affected by conviction rates on these cases. So we do find this to be a conflict of interest, but we also find it pretty unethical to do this as well. So we would like to see that particular issue removed. Another thing is we're trying to ask you for this next legislative session to help us move metric data from being confidential records, which I realize it's in Title 63, but we were looking for your help to try to move metric data from confidential records into public records. I mean, first of all, like, it's paid for by taxpayer dollars, so the public should have access to this metric data. But additionally, if citizen scientists, if data analysts, and other people can look at this data if it was made public, then there wouldn't be problems with data manipulation as much. It would hold the market more accountable. We'd be able to see these things such as inversion, which people are talking about all the time. Like these, it would help the community itself self-police and wouldn't require us to come to like the OMMA to look through the metric data or whatnot. So I highly encourage you to help us during this next legislative session to try to switch this into publicly available data. We also found it interesting that Oklahoma is one of only a couple of states that uses metric and doesn't allow the data to be public, and we were kind of questioning why that is. So if you could help us with that, that would be absolutely great. And I think that's it for my comments. Thank you.
Thank you, Mr. Havard, for your comment. And up next, Mo.
Hello. My name is Mo Miram-Biggie. I work at Havard Industries, and I'm also a patient. Clarifying what Jeff had just said about metric data being open, if OMMA is looking in the vested interest of patients and them making informed decisions, and also trying to hold the market accountable of possible inflation of numbers in order to help out certain players economically, I think it would make sense to open up that data to see what the trends are, and you can see what the averages that are coming out of certain laboratories in order to hold the market accountable, in order for patients to be more informed rather than having to have a filter, which is you all, in order to only where you guys have access to the data. It makes sense to make it more open if you guys have vested interest for patient health and patient power, pretty much the power for them. One of the things that's rough is over the last 5-6 years of seeing biologically impossible COAs out on the market. It's rough to then go, what's the credibility what's the purpose of audits? What's the purpose of any of the inspections if you have biologically impossible COAs out on the market? If they're impossible and the authority goes to these other conferences and gets informed of other cannabis states and what the realistic numbers can be and are, then it kind of removes what the reasoning is to not address those issues. So then what is the purpose of having an audit if you're not going to look that direction when there's COAs, I remember in the past, that added up to over 100%. It just isn't possible, and yet some of those labs are still operating. With us being a transparent and live streaming our laboratory, we've been trying to increase trust and accountability. We've been wanting people to come on the stream, ask us questions. You can see our quality controls. You can see our methods. With our state being 50th in education, I think we can be first in honesty. And like the heart of Oklahoma is, in my opinion, of growing up here, honesty is like a big beacon of what I thought we had here and what I thought was like a tried and true thing of being an Oklahoman. And to see it kind of actually, the government not assisting in that and not feeling, not using that platform politically and even trying to increase that conversation. We want a roundtable conversation of what the science could be, what the science is, and what it should be. That's why we dropped trowel and we're like, this is what it is. This is what the science is. And we're not seeing anybody else kind of come to the table, especially with the two QA labs, which the second QA lab is now coming up. The first QA lab was a waste of $10 million. Did that equipment get shifted over? You don't need $10 million to have an honest laboratory, and especially whenever childhood education is what it's at. From what I've heard from a lobbyist was $800,000 for pre-K education for all of Oklahoma citizens, and it's kind of absurd that we can blow $10 million on a QA lab that did no quality assurance. So not trying to be adversarial, it's just disheartening, it's rough. Thank you for your time.
Thanks for your comments. Up next, we've got Gary Wilson.
Good morning, everybody. My name is Gary Wilson. 6.5 years ago, I'm a disabled Marine. I've been in business my whole life. I decided I was going to enter a regulated market that we'd established. When I got into it, what I realized is that it wasn't regulated at all. 2 years in, no inspections. When I go to deal with dispensaries, I would go in there doing everything by the rules, even when nobody was watching. And I would go in and I'd see inconsistencies in front of my face. People traveling in, selling on the spot, people coming in with COAs, impossible COAs, which is like you running a gas station, selling dollar gas, but nobody realizes their car is going to blow up in 5 years because there's no safety for the patient, and this market is false. So if I'm running a consistent and honest business, what happens to me? I go in front of them, my product is devalued, so the motivation is to crush somebody that's doing it right and trying to make a quality product that's safe for their customer because it costs more. It takes good processes, no pesticides, etc. That costs money to do. And if I can only get 75% or 50% of the value of somebody that's getting BS lab results, obviously, how can you get zero yeast and then turn around and do a side sample on this and get 4,000. It's BS. How are you going to drop 10 points on a 30-point scale for the efficacy of the product? In my opinion, we need to free the metric data so we can see what's going on behind the scenes. We ought to be able to analyze this data. At this point, I don't know if it's just incompetence. I heard in the beginning, hey, this was thrust upon us and we weren't ready. How you weren't ready, I don't know. Because plenty of states were doing it. There are plenty of examples of what works and doesn't work. But I let that go in the first couple of years. But at this point, we're over half a decade out, and we're still seeing all of this inconsistency. We're seeing all this incompetence. It's either incompetence, wildly incompetent, which means heads should roll, or it's incompetence by design, in which case heads should roll. This is unbelievable how this runs. The DMV used to be the gold standard of bad service. For me, OMMA has cleared them away. I don't understand the secrecy, moving meetings more towards secrecy. This is the realm of racketeers and corruption, and it just makes me wonder what is really going on behind the scenes. And these things come and go, but sunshine will come down on this, and it will come out, and it happens over and over. And I'm just telling you, I was done wrong, and this is real money, real people, and I don't know if anybody here really cares.
Thank you, Mr. Wilson, for your comments. Up next, Ms. Steph Davis.
I'm thankful the mic's still on, so I didn't have to try to figure that out. Good morning. My name is Stephanie Davis with Amber Law Group. Our firm represents a multitude of medical marijuana licenses across the state, but previously I worked in OMMA's legal department. So I have a unique experience and perspective on these rules from both sides of the aisle. I'm here to oppose several provisions in the proposed rules that undermine due processes for licensees. The most significant change is replacing administrative law judges with hearing examiners. This isn't just a word change. It fundamentally changes who decides these cases. An ALJ is a neutral decision maker who doesn't work for either side. Currently, OMMA contracts with the Attorney General's office to use an assistant general counsel. A hearing examiner will be an OMMA employee. Under these rules, OMMA will investigate cases, file charges, present evidence, and through its own employees, decide the outcome. This eliminates the separation between prosecutor and judge. The current ALJ system provides fair hearings where both sides can present their evidence. When we replace independent judges with agency employees, we lose that balance. These changes shift the focus to winning cases rather than achieving fair outcomes. During my time at the authority, I saw firsthand how independent ALG oversight created meaningful checks and balances. When there was a disagreement about consent orders on the grow signs, the ALG's independent perspective prevented overreach and ensured fairness. That oversight already disappeared when OMMA Legal's leadership removed the oversight with consent orders. At OBNDD, respondents lose at the administrative level nearly 100% of the time under this model. That is not a coincidence. It's the inevitable result when the referee works for one team. Good businesses with legitimate defenses cannot get fair hearings, forcing expensive district court appeals. For my time at OMMA Legal, I know discovery moves cases forward and leads to settlements that serve everyone's interest. These rules systematically dismantle discovery rights, requiring the hearing examiner's approval and cutting the deadline, which is currently 30 days. We need to allow hearing examiners not to block licensees from obtaining these documents or witnesses needed to present their defense. An OMMA employee now decides what evidence licensees can gather to defend against OMMA's charges. Without meaningful discovery, licensees lose at OMMA by default and must appeal to district court, paying twice for their due process and extending their non-operational status by several months, even years in some cases. These rules don't serve public safety. They serve administrative convenience.
Thank you, Ms. Davis, for your comment. Up next, John Bird.
Thanks for letting me speak. I'm John Bird. I represent Oklahoma Knights Craft Cannabis and some other small rural farms. Want to be real brief. Don't want to badmouth. I have problems with this administrative thing. I have seen the OBN administrative. It is 100% loss. Doesn't matter if you do everything right, you will lose. And for OMMA to want to actually take that away from us when they can't even figure out a med portal is it's just crazy to me. It's like slow the roll, figure out your guys' job first before you go try to be our judge, jury, and executioner. That's just my biggest complaint. Other than that, OMMA hasn't done me wrong. It's actually been pretty easy. But to allow you guys to tell us what we can't do, can't see, and what we have done wrong, even though it's not wrong, because I've never been hit with a bad inspection. But I know people that if the inspector feels like it's wrong, he can just do what he wants. And then to go into a court proceeding where it's 100% guaranteed to lose because you guys want to be our judge doesn't give me, as a citizen of Oklahoma, born and raised, the right to be able to fight it. I'm a small farm, so money is limited. I focus on quality product. I just killed a harvest because I didn't think it met an Oklahoma standard. And I would just like to actually make sure that my voice was heard and that you guys taking an administrative hearing away from us is a just total violation of my Oklahoma right, which I thought was afforded to me in our Constitution as a business owner in Oklahoma. I have the right to sue you before a judge, and the same thing, you have a right to sue me before a judge, not one of your employees. That's what scares me, and that's all I had to say. Thank you.
All right, next we've got Nick Serrano.
Hello, thanks. My name is Nick Serrano. I'm the owner of Southwest Genetics, a nursery here in Oklahoma City. Most of the participants have already spoken about most of my concerns for the new proposed rules. So I just want to tell you guys thank you for the new inspectors. They've been pretty nice. I've had no issues. But this kind of brings me to a concern that I have. I would like to take this time to address a bigger issue for this panel, and specifically to Ms. Portia Riley. That issue is 1 pound is equal to 1 plant. I want to know, why does our licensing authority allow OBN to go unchecked and outright publicly contradict what we do? I believe this hurts all of us, especially OMMA. OBN is destroying OMMA's credibility with this. They're stigmatizing all of our licensees here as if we are supplying the entire United States with illegal weed. The numbers, it seems intentionally misleading the public. It could be incompetence. Maybe they don't understand how growing works and the production scales. But what they're putting out there, and I see on KFOR, and I've seen some web pages just hosting some of the stuff with Texas, receiving all this illegal weed, and that we're producing all of it. It's kind of crazy. And I would just like to see a better job from you guys in contradicting OBN publicly to let this go checked, what they do, because it's bad for everybody. That's all. Thanks.
Oh no, I'm going to struggle with this one. Next up, we've got Mr. James Sersh. I butchered that. I know I did.
All right, son. Yeah. Okay, I'm James Sersh. I own Pollination Cultivation, Little Grow in southeast Oklahoma. One of my main concerns is the wait times when we call in. Yesterday, I think, or the day before yesterday, we were on hold for 5 hours and then got hung up on. And then there's no recourse or nobody to call back, or nobody's going to call you back or anything like that. So you're just kind of out of there. Yesterday, we were on the hold for 4 hours before we finally got through and got a couple questions answered. I don't know what your staffing's like at the call centers, so I assume y'all have a pretty decent amount of employees there with the amount y'all have hired in the past few years, but wait times it's just crazy to have to hold that long, and then especially get hung up on. I've dealt with the IRS and stuff like that. It's kind of the same thing. You can hold for 8 hours and then you're just stuck. So that's probably one of the biggest issues that I think needs to be addressed is why is it taking so long for some of these questions to get answered? And a lot of them are just basic, really easy to handle things, but it eats so much of our time up to have to hold for 5 hours, and you really can't do anything. You can't answer any other phone calls. Like, you have to leave that line dedicated because, God forbid, you click over and answer another call and you go back and then you've missed it and then you're right back in that same situation. I think really that's my main thing. I think everybody else has covered, the majority of, our other issues. I am curious, where's the board members? Where's everybody else? Like, what happened? Where's Adria? Where's Sheriff Tommy Johnson? Where's the other couple folks that are on the board? It's really weird that we have a board, but yet we can't. This is our first. I've come to many meetings. This is my first chance to actually talk, but we can't even get a hold of the board members to be like, "Hey, can you bring this up at the meeting?" Nobody wants to talk to you. I've reached out to Sheriff Johnson. I've reached out to the majority of them, and it's just, you don't get any info back. Only one of them has actually been kind of helpful, and that was, I think her name's Katie. She's the nurse practitioner, I believe, that's on the board. She's been pretty helpful. The other two guys that are actually in the industry, which are the only two ones who actually have licenses and stuff, and they're tough to get a hold of, and I don't know that what their agenda is either. And I'm kind of curious how these people even got on the board, some of them, because what are they doing? You know what I mean? Like, I don't understand what they have to do with the industry, and the board's kind of confusing to me. Thank you guys for your time. Appreciate it.
Thank you, Mr. Searsha, for your comment. Now, Mr. Jed Green.
Are we on? Good to go? All right. Thank you for doing this, and thank you for the red underlines. It makes all the changes easy to see. I will never stop saying thank you for that. I want to run over just a couple of things real quick. I'm not going to cite, but I want to provide some feedbacks and some things for y'all to consider. When we're dealing with the testing, specifically the yeast and mold, I remain in the position that we need to take a look at actually raising what the CFU is. Other states have a much higher threshold. I would also suggest splitting yeast and mold. Yeast is actually beneficial in a lot of things. I'd hate to see a yeast test on a beer. I would also like to mention that when we're talking about that, aspergillus, I guarantee you guys that if we ran an air test in this room right now, all of us have actually inhaled more aspergillus in this room than what would fail a test. That's real, okay? A couple of, and it's just a perspective, there are a couple other things that folks have brought up. One, and some of the things that folks have brought up here today, say grower bond or the signage that is outside, those are ultimately statutory requirements. And I would appreciate when you guys respond to this, if you would respond to these questions, if you would specifically go ahead and point out for folks, hey, this is a statutory thing, you're going to have to take that up with lawmakers. Our group is, obviously working with lawmakers, and we're looking for these things. If you guys are hemmed in from making a change, flag it, and then we can go take it up with those guys. That would be helpful in the deal. I definitely see people's concern about switching to a hearing examiner from an ALJ. Also, when we're talking about what the authority deems to be a correctable violation, it really would be good to have some sort of a list. Now, what that looks like, how we get there, I'm not 100% sure, but there is a fundamental thing here, and that is a lot of the violations that these folks are getting rung up on, probably would be a correctable violation. Think of out of 5,000 plant tags, the 3 that fell on the ground that day. That's a correctable thing. I hope hopefully the new system gets sorted out and folks are able to get inspection reports more quickly, that we can kind of look at that and maybe OMMA, get more over towards on some of these things, say, hey, and this is so typical with other agencies, hey, you got a screw loose, you got this, you got these 3 tags, get it in the report, make it a correctable, and it's going to, drop a lot of need for ALJs. Just something to consider there. One thing else, it's not specifically in the rules. Could I take a point of privilege? Thank you. Let's look at something else. When we have a software issue like we have, which, being fair, this is probably rooted in Salesforce. It's probably rooted in OMMA and what that takes to work all that stuff out. I'll just say that. But something that I've talked about for a couple of 3 years now, and maybe this is something we do need to address with lawmakers, is what can we do to have you guys recognize third parties to deal with these licenses, be it child custody, be it tax. We can appoint a point of contact. OBN allows us to do it for these businesses. That, for example, let's say that right now you got a situation where you've got someone that's got 100 employees and they're currently being required to have every one of those employees call in order to fix their stuff because of the debacle. Wouldn't it be so much easier if you were able to allow a POC to just run through that list? There are definitely some situations here, and look, a lot of these folks are small operators, but let's face it, some of these businesses are, you got a couple of guys that own the deal, they probably own a whole bunch of other stuff, and they'd really just assume hire someone and have them on staff as being that POC, so that's just something to kind of, something to think about there. And if that's something that we need to talk with the lawmakers about, then I guess we could, but that's there. Off the top of my head, that's basically it. Oh, the last thing, what I actually signed up to talk about, the definition of marijuana, and this is just to kind of throw this out there, we see where there have been changes made in cannabis regulation at the federal level, starting with a spending bill that changed up the definition of hemp, and also now a potential push, although it'll happen when it happens, towards Schedule 3. And so what I'm looking at is that in Oklahoma law, we are actually very, very close to what those federal changes were. And I bring this up in definitions, and this is something that you guys will be aware of, but what I intend to ask legislators to do is to remove the prohibition from the definition of marijuana in your section of Title 63 on OMMA being able to regulate Delta 8 and Delta 10. It's THC, it's in the dispensaries. You guys are prohibited by law. We need to remove that out of the definition and just get it clean. I think that'd be helpful, and I'll also maintain that any THCA that is in your dispensaries that is marketed as hemp, marijuana that is being sold as hemp, guys, that is under your authority right now. It's untagged marijuana. When we really dig into it, I appreciate the director's comments at the last EAC meeting regarding this, and if we need to get a little final clarity from lawmakers, I think that behooves everything. Outside of that, appreciate everyone that's come here today to talk about this. Appreciate the work that you guys are doing here. And in line with kind of what we're seeing today and what some of the frustrations that you heard with the EAC, the movement that you guys put together and discussed at the last EAC with allowing a public comment there like this that would allow folks to come in and say, okay, it's not a rules thing, but hey, we're having these issues. I think that'd be absolutely wonderful. I really do. Sheriff Johnson's very well aware. Oklahoma County's got a model. I think you guys threw a model out that would work to do that, but I think that'd be a good deal for folks that care enough to show up. So anyway, I appreciate you guys' time. Thank you.
Thank you, Mr. Green, for your comment. And last, we have Justin Wood.
Cool. Someone left it on. I don't have to figure out technology. Awesome. Morning. Happy New Year. My name is Justin Wood. I run a company called Shock Top Processing. I have a unique perspective on this market because I'm not a brand. I'm a brand manufacturer and a wholesale producer of oil, distillate, cured resin, live resin. That being said, my first thing that I wanted to talk about was the testing labs. We've had a couple people up here talk about the variances that we have across the board. Of this lab's 30%, this lab's 26%, yada, 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 yada. We've spent a lot of money to get this QA lab up and running that should basically nip all this intermingling and hostilities that labs have against each other, just to kind of cut it out. Wanted an update on what was going on with that. The second thing I had was classifications on products. I talked about this at the last public hearing, I think it was last year, basically stating that whole plant fresh frozen can only make live resin or live rosin. Cured biomass can only make cured resin or distillate. We have a lot of products out here that in a medical market are lying about what their products are. For example, people selling live resin as distillate, cured resin as live, yada, yada, yada. We're a medical market. There's medical effects to all these things. There's patients that consume cannabis for epilepsy that can have seizures if they smoke distillate. Just looking for more transparency in the market. And then I think the last thing that I was going to talk about was correlating to the metric data being open for all of us to look at it. We had the OBN yesterday come out and say there was, 85 million pounds of marijuana that's missing. A street value of that brings that up to $38 billion. So if there's $38 billion of weed missing in our state, I think we got a pretty big problem. We're 50th in education. This is the fourth state that I've operated in. And I can tell you that I've seen tax revenue help education, help roads, help healthcare, help everything. That's what this program was put into effect for. And I'd like to get back to that instead of us all in this rat race of trying to figure out how we operate under your guys' jurisdiction, OMMA, OBN, all that stuff. Let's get the tax revenue to where it's supposed to go so that people can stop laughing at us, because at this point when we have that guy going out saying there's 85 million pounds missing, that's a laughable thing. That hit national news. It's all over the country. I have cannabis operators in California being like, oh, goddamn, that happened? What's going on with that? I like this industry that's now evolving away from all the malarkey that it was years ago to actually stand up, stand tall, stand proud, and be what I believe Oklahoma's all about. I'm not from here, but I've heard enough people talk about how honesty, transparency, and loyalty is what this Oklahoma stuff's all about. Well, cool, I'm here for it. That's how it is in Massachusetts. I'm from Boston. Loyalty and integrity is life. So if we could evolve to the times, be a little bit more current, and tackle 2026 unified and together instead of this divided crap that we're all doing, that would be great. So I appreciate everything. Appreciate everybody's comments today. Everybody had a lot of cool things to say, even the one guy that got a little upset. Let's just get this done, man. There's a lot of money on the table. We got a rescheduling coming up. A lot of people can start actually operating like a normal business. We can hit banks and not be persecuted. Give me another 20 seconds and I'll get out of your hair. Just let's all come together, guys. At this point, we've all been in this industry and spent a lot of money, had a lot of headaches, a lot of setbacks, and I've helped a lot of people kind of right their paths and fix things, and I'd like to continue to do that with our regulatory agency and OBN if at all possible. So let's crush this year, guys. We made it through the really hard times, and let's all just really focus on coming together, because that's what my that's what my building does. All I do is make other people's products. I moved here to Oklahoma to elevate the product level of everything that goes out. And that's my mission. So I appreciate you guys and your time. Y'all have a great rest of your day.